Hey everyone, welcome back to the Regent Law Podcast. On today's episode, we'll hear from Jim Campbell, Chief Legal Counsel for Alliance Defending Freedom. Once again, he's interviewed by Brian Stokey as part of our series on the administrative state. Thanks.
And finally, we're going to talk with Jim Campbell, Chief Legal Counsel for Alliance Defending Freedom. Jim, thanks for joining us.
Thanks for having me.
Appreciate your time. Thank you for coming. Obviously, we're here at the Regent School of Law Annual Symposium. This year's topic is the administrative state. But before we get into that, if you wouldn't mind, could you just tell us a little bit about your journey to the role that you're in now? Obviously, you don't graduate law school and then, step right into senior legal counsel at ADF.
Yeah, so after law school, I clerked for a federal judge at one of the federal courts of appeals, which was a phenomenal experience, a good opportunity to learn more about the law, to see it from a different perspective instead of seeing it from the advocate's perspective, seeing it from the judge's perspective. Did that for a year, and then I went to ADF and worked there for 12 to 13 years, and that's really where I learned how to practice law. Got to argue lots of cases and depose a lot of witnesses, and got to get in court and just do really meaningful work. And then eventually I had the opportunity to leave ADF and to go to the Nebraska Attorney General's office and to work there as their Solicitor General. Did that for between 3 and 3.5 years. And then recently I returned to ADF to work as the Chief Legal Counsel.
That's fantastic. And obviously, it's a pretty quick transition to ADF. Was work like what ADF does passionately? Was that something that inspired you to go to law school originally?
Yeah, actually, to be candid, it really wasn't.
Sure.
I when I went to law school, I just thought I would go to a big firm and do business law and represent corporations. But the summer before I started law school, I did an internship with a really small firm down in Florida, and they had 2 Blackstone fellows. And the Blackstone Legal Fellowship is ADF's internship program. So that was my first introduction to ADF, and as a result, I decided to apply for the program myself, and I got in, and that was really what changed the way that I approached the law.
Awesome. What a fortuitous interaction. One might say providential.
One might say.
So obviously the topic that we have here today is the administrative state, and we'll talk a little bit about it. But before we dive right in, at a very high level for some of our listeners who might not be as familiar, how would you describe the buzzword administrative state? What does that mean for you?
Yeah, so we have this 3 branches of government. We have the judicial branch, the legislative branch. Judicial branch decides cases, legislative branch makes laws, and then you have the executive branch. The executive branch primarily enforces the law, and the way that they do that is they create all of these executive branch agencies, also known as administrative agencies. And so what those agencies do is broadly known as administrative law.
Awesome. And oftentimes that buzzword of administrative state has a negative connotation to it. Especially in conservative circles. What you just described there seems as though there's, it seems like a healthy balance of administration of the executive branch. Could you explain why it's worth talking about, why there might be negative connotations associated with the administrative state?
Sure. So if those administrative agencies steer from, instead of just enforcing the law that Congress has created, to creating the law themselves, or to taking the law that Congress has created, and instead of faithfully administering it, they're instead slanting it to promote their view of what the law should be, then that's when it becomes a problem. And as the administrative state gets bigger and bigger and bigger, it becomes easier for that to happen because there's so many agencies doing so many things, and it's hard to keep an eye on all of it. And so it's easier for those agencies to get into mischief, if you will. And if Congress isn't willing to hold them accountable, which oftentimes Congress is happy to allow administrative agencies to do the day-to-day policy work that, frankly, Congress should be doing more of itself, then it becomes a problem.
And I think that what you just touched on, the accountability, is kind of where a lot of your career has been focused, at least, through ADF, through the judicial system, holding people accountable to what the law actually is. And I think that in your position as a litigator, have you seen any really big wins that you could share with us about, holding the administrative state accountable?
Sure. Most recently, I had a case that I litigated before the U.S. Supreme Court, a challenge to the Biden administration's student loan forgiveness program. And that was a situation where in the summer of 2022, the administration announced that it was going to forgive over $400 billion of student loans. And so we in the state of Nebraska joined with 5 other states, filed a lawsuit challenging that. Ultimately, the case very quickly went up to the U.S. Supreme Court. The court took the case. The court thankfully ruled in our favor, struck down what the Biden administration was trying to do, and made it clear that there was no congressional authority allowing the president to do that.
Not saying that I had a case in mind, but that was the case I had in mind. So congratulations, by the way. And, sorry to all of those of you who might have been less happy about the decision than Jim. But just a quick question. Does it feel like does the high wear off after a couple months? Because that just came down this summer. Do you still look back and, think about the fact that you did that? Obviously it was a team and there were other states involved in that, but, does it wear off, or do you still get giddy thinking about it?
Well, I think it does wear off because there's so much other stuff going on, and it's like you achieve something, and then you're off to the next battle, the next case. But I will say this: I was scanning the decision again earlier today, and every time I read the decision, I get excited and get chills and goosebumps over it because it was a fun experience.
That's really, really neat. What makes the administrative state hard? Obviously, you have a win. What makes it difficult to address in court? Is there any aspect of the administrative state or administrative agencies and their overreach that makes them a hard thing to attack in the judicial system?
Yeah, so the primary way that litigators attack these administrative actions that are problematic is something called the APA, the Administrative Procedures Act. Well, generally speaking, the way that you file lawsuits under the Administrative Procedures Act is when there's what's known as final agency action. So what these agencies do is they engage in gamesmanship. They'll create what's often known as sub-regulatory guidance. So they'll issue a guidance document and they will say, hey, here's how we understand the law. And then if that adversely affects someone, they'll go into court and they'll say, wait, I'm challenging this because this is going to violate my rights. And then the agency will come into court and say, well, wait, that's not final agency action. That's not an official rule. That's not official proclamation. That's just we're just telling you our view on this thing. So it actually makes it pretty hard to challenge some of these agency actions when they're not in their final form.
So what happens when lawyers get involved in things, make it difficult to attack? What's something that you would look for then? Let's say that you were looking for a particular situation to address. What would make a situation ripe to litigate and actually bring before the court?
Yeah. So when the classic form of final agency action is when an agency creates a final rule and publishes it in the Federal Register. When that happens, it's pretty clearly final agency action. And so you're able to go into court, and the federal government doesn't have those sorts of arguments that they can make to try to duck the question. They have to face it head on. And when they have to face it head on, then they have to show the court, where did Congress actually give them the authority? And that's when you can really fight over those important issues.
How do we, as individuals that see a problem with the administrative state as the buzzword, not necessarily just as a concept, but how do we effectively and kindly market our position to those that might have come to love the alphabet agencies?
Yeah, I think one way you can do that is by talking about the concept of political accountability. And so people like you and I, we voted for our legislators. We voted for the people in Congress that represent our interests. And so it's reasonable for us to be, quote unquote, stuck with whatever those legislators do. but we did not put in place the head of the Department of Labor, the head of the Department of Health and Human Services. And so there's an additional lack, or I should just say there's more of a lack of political accountability for those officials than there are for members of Congress. And so for that reason, if we really are a democratic republic and we the people do still have the power, we're losing more and more power to the extent those agencies can exercise it instead of Congress.
How does it change from, and this is something interesting with the presidential election coming up, how does it change from administration to administration how the administrative state is used?
Yeah, I think I've often talked about this. So you'll have 4 or 8 years maybe of one administration, and they will accomplish whatever they can accomplish in that time. And during that whole period, they're facing constant lawsuits from states on the other side of the political aisle, from business interests and other sorts of political and special interests on the other side that are challenging what they're doing. And by filing those challenges, you're able to slow down what that administration is able to accomplish. And then eventually the power shifts back to the other party, and then everything flips. Mm-hmm. So then the states on the other side are now filing the lawsuits, and it becomes somewhat of, I don't think it was the way the system was designed to work, but it does become a check on the power.
It's an interesting, definitely not how it's, and it's almost like an organic development mm-hmm. that you needed to evolve to create that check and balance that is destroyed by the fourth branch of the administrative state. It's an interesting that it organically developed. What's something that you personally or ADF would like to see in the future moving forward as far as the administrative state goes?
Well, at ADF, we've created something we call our regulatory team. And we know it affectionately within our walls as the Biden Accountability Project. And so we want to keep filing lawsuits through that team as we see the federal government pushing the law beyond what Congress allows. And we're going to keep doing that. I would say we're also going to look for opportunities to chip away at the breadth of the administrative state. And so I personally am not a believer in some of the plans that I hear that, we're going to have a new administration come in and they're going to fire 80% of the workers and shut down all the agencies. I just don't see that sort of overnight solution happening. But I do think that it's important. You can take a really big agency like the Department of Education, and you can take one of the dozens of things that it does, and you can have Congress take that power away from that agency and say, we're just going to let states handle that issue themselves now. And if you do that enough times over enough decades, you can begin to shrink the size of the administrative state. It's not an overnight project, though. I think anyone that thinks that they're going to just come in and shut down most of these agencies, I don't see that as a feasible solution.
So does the correlation between the Biden accountability team, does that mean people will get some time off approved here and not too long, hopefully?
It may be, although I like to remind people that no matter which party is in power, there's still regulatory work to be done. And so just to illustrate the point, if you generally oppose the administration in power, you're going to be filing the lawsuits that are challenged with the regulatory actions. On the flip side, if you generally like what that administration is doing, you're going to be submitting comments that support what they're up to. You're going to file amicus briefs in cases defending what they're doing. You might even come in on behalf of an intervener party when those regulations are challenged that you like, and you will come alongside the government and help to defend it.
The work never ends.
The work never ends.
So obviously a lot of the conversation about the administrative state happens at the federal level. We talk about the federal administrative state. What could states, and I think a lot of this is true of a lot of ADF's work, what can state governments be doing in the meantime at a state level to be kind of fight back against that federalism issue?
So,
or is there anything to be done?
Yeah, I mean, one thing you can do is if a state passes a law that is preempted by one of these bad federal regulatory actions, then you make it clear that your state has an interest in challenging it. So by doing that, you can give your state the opportunity to go into court and challenge it. One of the things where I thought you might have been taking that question is, what can we do at the state level to make sure that the state regulatory apparatus doesn't get too out of control? And that's a whole nother issue. But I think because at the state level, the legislatures are willing to do more than they are at the federal level, that you can have a state legislature enact a bill that simply says, when courts construe state regulatory action, they shall not defer to what the agency does, but they should instead construe the law consistent with how the courts understand it. That would be a way that the legislature could get rid of a concept like Chevron deference within its own state. So there are plenty of things that state legislatures can do to ensure that state regulatory agencies don't get too much control.
And I think we've seen that recently, right? 7 states, 9 states have stepped back at the state level from, whatever Chevron deference they'd enacted at the state level. I think we've seen some states actually pulling back and drawing away from that, which I think is good news.
Yeah, we've seen it both at the state judicial level as well as at the state legislative level. So I think recently 4 states legislatively have acted to get rid of any kind of Chevron deference. And then state Supreme Courts, there are about 7 or so of them now that have made it clear that Chevron deference is not a principle that they apply within their own state.
Back to something you said about state legislators being willing to have action and make action and act on this issue. I think that touches on something that Professor Joe Postel said just previously this afternoon. And he said that the issue in his mind is Congress being willing to let their power slide to the administrative agencies. Would you concur and say that that's the squeaky wheel, so to say?
I do, because keep in mind that anytime a regulatory agency does something and purports to be exercising the authority that Congress gave them, Congress could step in the very next day and act a law that makes it very clear, no, that is not what our law meant. And so anytime a regulatory agency gets out of hand, for the most part, there might be a few exceptions, the Congress can step in and could end it right then and there. So the fact that they don't just shows that Congress is not willing to step up and address these issues. Now, I do think we have to realize that the federal government is really large. And so the fact that I think it's unrealistic to expect Congress to be able to legislate on every minute detail. And so there is a role that I think administrative agencies can play, but it's way beyond what they're currently doing is way beyond what they should be.
Is there anything that we as individuals that are interested in the litigation that surrounds this type of issue, is there anything that's in the pipeline right now that we should be keeping an eye out for, or that might be coming up either at a district court level or circuit somewhere out there?
Yeah, I mean, there's a case right now pending. There's a request for the U.S. Supreme Court to step in one of our administrative law cases. We filed it on behalf of a group of doctors. It's called Alliance for Hippocratic Medicine versus the FDA. It's a challenge to the FDA's approval and then subsequent deregulation of chemical abortion drugs. So those drugs were approved in 2000, and then starting in 2016, there have been efforts by the FDA to take away safeguards that were in place to protect the women and girls who were using those drugs. Like, so for example, they used to have to see a doctor before they could have those drugs prescribed to them, but now they no longer need to do that. So we filed a challenge saying that the FDA violated the law by removing those safeguards, and the Fifth Circuit Court of Appeals just last month agreed with us. And so that ruling would result in those safeguards going back into effect, which is a significant win. But we now have the FDA filing a request with the U.S. Supreme Court to take up the issue and to hear the case. So I think it's a fascinating case. It's very interesting set of administrative law principles, and it's a case that might see itself before the Supreme Court before we know it.
Well, we'll have to keep an eye on that one. If listeners want to hear more about the Alliance Defending Freedom and what they're doing, where should they go?
adflegal.org. So adflegal.org.
Okay. And is there anything else before we end that you think would be important to note for the listener about the administrative state, either moving forward, things that we hope to see, or changes that you would like to see personally?
I would just say keep an eye out on this Loper-Bright case that's before the U.S. Supreme Court this term. The court has been asked to strike down the Chevron deference doctrine, which is the doctrine that tells courts to defer to an agency's interpretation of a statute. We think that the better rule is that agencies shouldn't get this kind of deference, but courts should construe the law the best way that the courts can, because the ultimate province of courts is to interpret the meaning of laws. So that could be a very important win. It could change the landscape of what's going on in the federal administrative state.
It'll be really neat to see. So Loper-Bright?
Loper-Bright.
Okay, we'll keep an eye out, and keep an eye on Alliance for Hippocratic
Medicine.
Alliance for Hippocratic Medicine. Awesome. Well, thank you, Jim. Appreciate your time. It's wonderful to have you here for our symposium, and hopefully have you back here sometime soon.
I'd love that.
All right. Thank you.